Can you hear me? Yes, it's very odd, you know. It turns red when it comes on, and of course, when you're driving a car, red means you stop, but here it means you start. I think you all have the program, and you all have the biographical, all the bios about us. I'm not going to read them out. I'm going to make a few remarks. We have three panelists, Pilar Perales, who is there, who I've known, Stefan Vogenauer, who I've just met, and Fabio Bortolotti, who I gather is behind. Can you see? Is he on the screen or not? Anyway, he's unable to join us, but you have his paper, I think. It's in, I think it's on your tables. And after I've spoken and my two colleagues have spoken, Fabio, I will call upon him as the first Q&A person. I think I haven't left anything out, but if I have, Anna will wave at me. You've heard the important part, I think, of this panel already, this program, rather, this conference, because Joachim has spoken about the present and the future. And I come from it was a young country once, the United States. We always did believe in the future. I continue to, my generation does. So the future is what we really should be focusing on. And I think we will in the last panel that Ignacio will chair. I've been asked to speak about the historical roots. My colleague's going to speak about certain synergies, is the word that's been used. Since I am hoarse, forgive me. It's neither age nor a cold. I don't know what it is, actually. It's probably general physical decline. In the morning, I'm very clear. But as the day goes on, so I'm going to read my comments, if I may. They're very short. And as I say, you've heard about the future, the present and the future from Joachim. So I'm just going to take up the roots. And this is a dimension which really Joachim in the past has often addressed, the roots of and I'm not speaking merely of the four editions, but of the sort of historic roots. Why is there this objective demand? And I think to some extent it's implicit in everything that Joachim and everyone else will say, but I'll just focus on it a little bit. And I'm reading. I said, to mangle a metaphor, the roots of the principles lie in the absence of a good tree and the need to grow one. In other words, something was needed to pull together. So I've heard Joachim speak about lex mercatoria, not always in a complimentary fashion. We do have the reference to general principles, but as you know, it's quite unclear to what they even refer, let alone what their content is, although I've heard from Joachim that occasionally general principles will lead you to these principles. Incidentally, Joachim said he does not call them UPICC, and that means you have to know what the words stand for. He calls them. I'm sorry?
Ciao.
Oh, is that my Lord? You know, when I heard the honking outside, I thought this was in celebration of Joachim's talk. I don't know what this signifies, but I just saw Macbeth. It's a wonderful production. And you have witches and hallucinations, and we have Bortolotti. Well, welcome. Any case, if I may go on. Joachim says he does not refer to the UNIDROIT principles as UPICC, but he refers to them as the UNIDROIT principles. Well, I'm by nature impish, as I told Joachim's wife. I call them the Bonnell principles, but I'm told that's heretical, but that's how I've always thought of them. I know that's unfair to all the other persons who participated. I myself participated in some of this, but that's the way I think of them. And as I say, we needed a base to develop, a tree to develop the future. I said, maybe like democracy, the alternatives to the principles, though widely used, were worse or are worse, whether domestic law, which of course is an alternative, conflicts of law, the applicable law, and I add, or unguided party autonomy or choice. And we've seen examples of unguided party autonomy, you know, the principles of European law. And if we leave it to the Court of Justice of Europe, they will be mangled also. I'm interested in investor-state dispute settlement, and we've seen the Achmea case, the other case, which I think are rather mischievous. and as I say, this failure of the existing sources often lead to practical puzzles, what to do, to disputes, to litigation, whether for those and these puzzles are for those drafting contracts, counsel advising or litigating for their clients, and finally for judges and arbitrators. And Joachim has explained sort of what has happened. And more specifically, domestic laws are often behind the times. Legislatures often inexpert or resistant to change, even when legislatures can be persuaded to revise the general principles of obligations, et cetera. They don't always get it right. And they're politicians. In many countries, they have no professional staff. My work consists of advising many developing countries, and their parliaments are not staffed properly by and large. They're very able, the individual legislators. So it's very hard. It's an amateur hour. It's very hard for them to do it correctly. I said conflicts of law, which is another source, has its own problems, different rules, of course. A preference for the lex fori, the inability of a judge to correctly interpret a foreign law. That I've seen that even in my own country and elsewhere. As for party autonomy, which is, I suppose, in a sense, what leads us to the use of the principles eventually, and it has been much augmented in modern times. I mean, it's true. When I went to law school, which was long ago, the idea that a contract between someone in Denmark and Iceland could have as its governing law the law of Fiji Islands would have been thought to be ludicrous. Now, it may still be ludicrous, but it's sometimes been honored if there's some economic sector which the laws of Fiji are relevant. So party autonomy is now is on a march. On the other hand, party autonomy requires agreement of the contracting parties. And they're very reluctant to pick the law of the other country. And the other country is very reluctant to pick their law. Now, one final source, if one was familiar, as I used to be in the past, with big oil concession contracts, the contract itself became the proper law of the contract, which is quite unusual. That'd certainly be a great example of party autonomy, but that doesn't happen very much. So as I say, when you look at all when you can see why this tree has been planted, and you can, the penny drops that, in my view, the success of the principles may be inevitable. And in a way, when you look at the numbers that Joachim cited, the numbers are growing. I myself, when I first was drawn to the principles, was a skeptic. Not because I come from a country where a contract is a contract is a contract, and good faith, something for poets, not for lawyers. But I was a skeptic because I knew nothing about them. And indeed, that's a powerful problem. I was chairman of the International Law Section, American Bar Association. It's extraordinary how little lawyers have known about the CISG, or any number of subjects, ignorance. So, but in spite of this, I guess this ignorance is not indestructible, because slowly but surely it's being overcome in the fashion that Joachim has suggested. So I think, given the roots, the principles are really the tree that we needed. And I think we will learn more about that from my colleagues and from the other panelists. So thank you. I think in the instructions I received from Anna, I think Pilar, you come next. And in theory, I think we're doing pretty well. You have 15 minutes. You have 15 minutes, but we have a little extra time if you need it. And I will only use the bell, which I love to use sparingly. And then we'll have the one of the three voices from Macbeth behind me, and then the general Q&A. So Pilar.
So thank you very much, Don. It is really an honor for me to address this distinguished forum of scholars here in Rome at the headquarters of UNIDROIT, coinciding with the commemoration of the 30th anniversary of the UNIDROIT Principles of International Commercial Contracts. These principles, alongside with the 1980 Vienna Convention on the International Sale of Goods, CISG, represent the most significant instruments of contractual commercial law. I would like to express my gratitude to Maria Chiara, to Ignacio, and to Anna for affording me the opportunity to celebrate this important event. commemorating the 30th anniversary of the first edition of the UNIDROIT principles, is also a tribute to Professor Joachim Bonnell, the true architect of the principles, whom I greatly admire and had the privilege of meeting many years ago in 1996 in Carabobo, Venezuela, at one of the early dissemination events of the principles. I deem it unnecessary to recount the achievements of the two instruments under discussion here, the CISG and the UNIDROIT principles, in such a distinguished forum, even after the keynote speech that we have heard by Professor Bonnell. Elaborating on their success would deviate from the title of the presentation assigned to me by the organizers, which is the influence of the CISG in the development of the UNIDROIT principles. As it is evident, this title obliges me to consider the role of the CISG over the principle as the starting point, rather than the reverse, which would lead to the contentious and unresolved discussion on whether the UNIDROIT principles can be used for the interpretation and gut feeling of the CISG. This is not to diminish the importance of the title of this presentation. On the contrary, it serves as a crucial reminder on this significant anniversary that the UNIDROIT principles are tributaries of their own history, a history of the principles intricately linked and inseparable from the CISG, undoubtedly facilitating their acceptance by legal operators, also linked to the main international organization, the sister organizations contributing to the international harmonization of commercial law, UNCITRAL and UNIDROIT, which together also offer significant developments in a better understanding of contractual instruments, as we will be shown later by Professor Vogenauer. The roots of the principles, using the metaphor that we have just heard in the words of Professor Wallace, rest in the CISG, and from there, the principles are cultivated in an evolutionary process. In particular, the first edition of the principles in 1994 follows very closely the CISG. This is quite well known, and I don't need to stress all these similarities. There are indeed more similarities than differences between the two instruments. Obviously, the CISG was not the only instrument considered by the drafters of the principles, and several other instruments were also contemplated in the discussions, particularly at the final stage of the draft principles of European contract law were used more often by the working group. But indeed, the CISG is the only one explicitly referenced in the principles, and particularly in the comments and in the introduction on the principles itself. Special treatment was given to the CISG in the sense that language, sometimes verbatim, was adopted from the CISG, but not from other international documents. It is true that when considering the CISG influence on the principles, sometimes it's challenging to discern the normative origins for three reasons. One is that the significant antecedent of the CISG, and was mentioned also by by Professor Tirado, the 1964 Hague Conventions developed by UNIDROIT cannot be overlooked in this, history of the principles. Second, also in the history of the CISG as well. Second, because the antecedents to the UNIDROIT principles were in parallel to the CISG. And third, because the CISG reproduced classical rules of the les mercatoria, and so they were prior to their formulation by the CISG or by the UNIDROIT principles. It is not coincidental that in September 1979, with the CISG works practically finalized, during the 57th session of the Governing Council, and a large study group on the progressive codification of international trade law was established with the purpose of drafting the various chapters of the principles on the basis of the previous work made by UNIDROIT between 1970 and 1979. In fact, during the analysis made at the 57th session in 1979, it became evident that the ongoing work of UNCITRAL at that time on the draft Convention on the International Sale of Goods ought to be taken into consideration. The enhancements made by UNCITRAL over the 1964 Uniform Laws on Formation and the Sales Contract were carefully reviewed, and it was deemed desirable to await the outcome of the Vienna Conference at that time for March 1980 to minimize discrepancies between the texts that were not justified by their differing scopes. From 1980 to 1994, the working group, with varying in composition of its members, but Professor Bonner was always there as the chair, convened several meetings culminating in the adoption of the principles as we know in May 1994. In an accelerated world, revisiting history and employing historical methodology allow us to recognize the value of the past, which is an indispensable element for understanding the institutions that have been precisely, elegantly, and concisely shaped under the principles. At the time of the publication of the principles in 1994, 17 names are mentioned. These are the 17 distinguished fathers of the principles under the direction of Professor Bonal, the driving force behind the principles, or using Professor Wallace's words in the Liber Amicorum for Joachim, a prophet of the unification and the elevation of international commercial contracts. Among them, there are illustrious names such as Professors Farnsworth, Garro, Hartmann, Lando, and many others who contributed to the initial conception of the principles. Herein lies one of the first reasons to understand the intimate relationship between the principles and the CISG. Among many of these 17 fathers, as well as other participants in the project, we recognize a diverse group of scholars who also contributed from their respective national delegations to the creation of the CISG. Undoubtedly, we also recognize the most important commentators of the Vienna Convention, especially after the subsequent years following its approval in 1980 or the entry into force in 1985. As the development of the principles progressed, literature on the CISG was also included as part of the reference that served as the basis for the final text of the principles. Even discussion about the different position on the commentators are seen in the drafting process of the principles. Here, the classical masterpieces of von Kammerer's Lectrim, Honnold, Bianca and Bonnell, and others were the usual sources for the working group. The drafters of the principles embark on their task with the obvious advantage of their CIG knowledge, its formation process, its virtues, and its flaws. They function like archaeologists, delving into national and international legal, doctrinal, and jurisprudential sources to create and refine modern international commercial law. Naturally, they did so in the light of the newly approved at that time, the CISG in 1980, often invoking its text, objectives, terminology, and legislative history, particularly the political compromises and whether and how those political compromises were able to be overcome by the principles. It is interesting to note that when facing with the CIG solution and the legislative history of the convention, the drafters of the principles face with an inherent tension arising from their own convictions, doctrinal works, legal education, and positions in Vienna. And as such, we see how the provisions of the principles were shaped and built at the expenses of their own sacrifices. This group of jurists were well aware of the potential global implication of leaning towards one of the various legislative options or formulations that were developed during the discussion, especially when they deviated from the CISG. This awareness stemmed from reasons of legal certainty, referencing the confusion that could arise from following different principles without substantial justification, as well as considerations based on common sense and the wide acceptance of the CISG. This collective consciousness extended to the evolution of the legal institutions over time with the 1964 conventions, later on with the CISG, until the completion of the principles in 1994. Numerous examples derive from the legislative history of the principles that illustrate this point, such in relation with Article 1.6, interpretation and supplementation of the principles, where the legislative history of the CISG, and particularly the principle of good faith, as well as the reference to domestic law, were seriously considered by the drafters, and where the result was indeed, from my perspective, better than in Vienna. The same happens with other provisions of the principles that follows the CSG, but with different results, such as Article 2.4, a revocation of the offer, where the compromise was not possible to be overcome by the drafters of the principles, or, for example, the provision of the usages of trade. The composition of the working group, as I have just explained, is not the only reason of the influence of the CISG in the development of the principles. More importantly, there was a conscious policy decision made by the Governing Council to use the CISG as the model for the discussions. This stance is duly acknowledged in the introduction of the principles in the 1994 edition, where the CISG is referenced twice to emphasize the international character of the principles and their inspiration from the CISG, and to underscore that the principles adhere to CISG solutions. Upon reviewing the travaux preparators, it's evident that the 1994 edition, in many of its provisions, is based on the CISG. This implies either a direct replication of the CISG provisions, the adoption of the CISG solutions, or the development of solutions akin to those found in the Vienna Convention by way of interpretation. A total of 16 provisions are expressly cited from the CISG. However, in some instances, the origin of a provision is not explicitly linked to its counterpart in the Convention, despite being indicated as such in the preparatory works. The CISG contributes to the principles a significant number of provisions that the drafters consider perfectly capable of being applied generally to any international commercial contracts, not just sales contracts. From this perspective, the principles and the CISG do not require interpreters, as they engage in a fluent dialogue by using the same lingua franca and create the same jus commune for international operators. The influence of the sales contract is strongly noted in the examples and illustrations contained throughout the principles, and also in the way of the structure, style, and interpretation principles contained within the text. As a conclusion, there exists a significant internal coherence between the CISG and the principles, to the extent that over time a mutual interrelation between both texts has become evident. While the CISG and the UNIDROIT serves as the source of inspiration and reference archetype guiding their development, the principles fill the gaps and address the deficiencies of the CISG. This brief retrospective journey doesn't end at the threshold of the first edition, the 1994 edition, the red edition, where the CISG and the principle stand as twin brothers. It was the starting point to build a true code of international commercial obligations and contract, full of colors. The history of the principles continued with the successive editions, expanding into new areas where the relationship between the CISG and the principles gradually attenuated, evolving from siblings in the 2004 edition. I would say orange edition, but I'm not sure whether it's orange or yellow, but in any event, let's stick with orange, to distant cousins in the 2010 in blue. However, in the 2016 edition in green, the relationship can be linked to a marriage. This latest edition aims to accommodate the special features of long-term contracts within the principles, shedding light on the CISG to adapt it to long-term sale of goods contracts, an area that the CISG certainly covers. I am finishing just 30 seconds. The story concludes today over the rainbow of colors and aware of what the future holds. Perhaps a return to the principles in a progressive codifying approach that they have demonstrated since their inception, and still at least with 3 more basic colors to go: yellow, indigo, and violet. We conclude at the moment of joy for the international business community in the historic celebration of the 30 years of the principles in Rome, UNIDROIT, and in the month of May, which evokes the signing of the first edition of the principle at the same time and place. Thank you very much for your attention, and congratulations once again to UNIDROIT for this important event.
Thank you very much, Pilar. You have the program and you know what Professor Vogenauer is going to speak about, but apparently synergies between UNIDROIT, UNCITRAL, the Hague Conference. Stefan?
Yeah, thank you, Chair. I think we share one thing today. I'm also very hoarse. I also attribute it to age. I wish I could say I'm clearer in the morning, but I'm not. But I hope you can hear me. I'm extremely glad to be here. I think the first time I was in this room was in 2002 when I came here naively looking for the library of UNIDROIT. I was in Rome on a private visit and I thought maybe I'll check out the library and see where the travaux préparatoires to the UNIDROIT principles are. This room was full of young avvocati taking some classes by some very serious Italian lecturer ex cathedra. So I stumbled across the corridor if you leave this room and go to your right, and was totally lost until a very charming gentleman came out of his office and told me his name was Joachim Bonner and helped me. And so I'm glad to be here and ex cathedra now professing to you, but I'll try to avoid that. I'll be the one for whom the bell tolls. So I'll be brief. Although my title is very long, it's been a title that has been designated to be by the Vice Secretary General of UNIDROIT, so I could not refuse. I read it out. It says synergies among instruments developed by the Hague Conference, UNCITRAL and UNIDROIT in the field of contract law and the Tripartite Legal Guide. And I'd like to take out two parts from this long title. The first is Synergies and the second is the Tripartite Legal Guide. Now, Synergies obviously evokes strange management consultancy speak, but I will actually try to replace this with something much more familiar to a lawyerly audience towards the end of my talk. I think synergies is almost like the theme of this conference. If you actually look at the various titles of the presentations that will follow later today and tomorrow, Pilar Perales Viscasillas has already very elegantly talked about the influence of the CISG on the UNIDROIT principles, and the smaller cousin of the CISG, I might add, the Limitation Convention that is often overlooked. You couldn't, I would argue, understand and properly interpret the UNIDROIT principles without knowing perhaps that the CISG is something like a background law, a term that's often used to the UNIDROIT principles. Later in this conference, we will also talk about the use of the UNIDROIT principles as a general contract law in the development of new UNIDROIT instruments like the Reinsurance Contracts Project or the International Investment Contracts Project. So the PIC is there, the UNIDROIT principles are there, looking to the CISG in the past, but also looking to new instruments in the future and somehow being an important link between these two. Of course, there's also a relationship of the UNIDROIT principles with other UNIDROIT instruments that are not so often talked about today, like the Factoring and the Leasing Convention. There is a lot of interaction going on with other international instruments, those developed by UNCITRAL, but also by other institutions. The UNCITRAL Convention on the use of electronic means for concluding international commercial contracts, or the ICC arbitration rules that obviously speak of rules of law like most other arbitration rules, and thus enable a proper and full application of the UNIDROIT principles. Or, as we'll hear in a minute, the ICC model clauses that have developed in a very peculiar symbiosis with the UNIDROIT principles, with each of these two feeding on each other in a kind of step towards, well, this is a celebratory conference, towards ever increasing perfection, we might say, in the area of international commercial contract law. But also, as has been mentioned before, there is a very close relationship between the UNIDROIT principles dealing essentially with substantive contract law and the Hague principles on choice of law in international commercial contracts, because they, again, would enable and do in certain cases now enable a choice, a full choice and properly acknowledged choice of the UNIDROIT principles as the law governing international commercial contracts. The UNIDROIT principles have been influential in shaping other supra-international instruments. We will hear about the OHADA project later in this conference, and they of course had a role in shaping domestic laws and an influence on contract drafting, and I think Eckhard Brödermann is going to give us an example later today. Now, it's clear the UNIDROIT are almost like a spider in the web of something we might call global international commercial contract law. They're linked to all these different elements. Now, it has been a traditional lament in the field, and a big Sandra has been Roy Good, who I think is not with us today. A big Sandra in a positive way, exhorting us to engage and get more coordination, because as he wrote in his seminal, in his seminal case,
in contatto per telefono.
This is not Roy Good, no. He has been reminding us that there is no proper coordination between these various instruments, although there is, of course, significant overlap also in terms of the personnel involved. And perhaps one of the issues has been that we have different formulating agencies that are perhaps sometimes competing, that are often collaborating, but there's no kind of superior agency that can properly coordinate what is being done. So these are the instruments that we're looking at. And because of this lack of coordination, UNCITRAL a few years ago suggested to get together for a project that might actually help with some kind of coordination. I now come to the second part of the title, and actually the title benignly abbreviates it as Tripartite Guide, but it's actually much longer. I now read it. This is the legal guide to uniform instruments in the area of international commercial contracts with a focus on sales, which was ultimately published in 2021. UNCITRAL was the organization formally in charge, but the Hague Conference and UNIDROIT were, as far as I could see, equally involved in the drafting of this document. And I now have to insert a disclaimer, because I was a member of the expert group, and what I'm going to say now is only my opinion. It's not meant to express the views of other members of the group or even of any of the institutions. The history of this document I have described at length in an article in the recent Festschrift for Ewan McKendrick, published at the end of last year. And obviously, as with all these projects, the speed hasn't been like lightning, but eventually the Tripartite Guide was published. And what is important is that the process ensured that all the three agencies, Hague Convention, Hague Conference, UNCITRAL, UNIDROIT, went through the various stages of approval for legislative instruments which do not amount to international treaties or conventions. So these are properly agreed, this is a properly agreed text by the three institutions jointly. For those of you who don't know it as yet, I certainly recommend having a look at it. It's available in all the official languages of the United Nations. So like the CISG, you can get it freely online in Arabic, Chinese, French, English, Russian, and Spanish. So the content is very much, almost you might say, like a textbook outlining the CISG, the UNIDROIT principles, the limitation convention mostly, but also looking at other instruments in the field. And the focus of this guide is to look at the interactions between these instruments and see how they actually can work and sometimes do work together in legal practice. Is this a 5 or a 1? It's a 5. It's a 5. Or is it an ultimate?
You've been very friendly, so it's a 5.
Okay.
Allora, attivio video e audio, quindi io ci sono. Sono visibile quando loro mi chiamano, però lei glielo spiega un po' bene.
Excuse me, please.
Come?
La sentiamo in sala adesso.
Ah, quello non va bene.
It looks like a 5.
Okay, I'll make it very brief. So
No, you-
the focus is on the interactions of this tripartite guide, and I think this is his greatest
Tolto, non c'è più il microfono.
Yeah.
Grazie.
We can
Arrivederci.
all read textbooks on the CISG, we can all read textbooks on the UNIDROIT principles, but the way they interact is perhaps not often that much explored. And in the said Fesche for you and McKendrick, I made the argument, and that is controversial, and again, this is my disclaimer here again, I made the argument that this legal guide, although it's called a guide and it explicitly says it doesn't want to put forward rules, it still has normative force. We cannot ignore it if we have a certain case, because it has the combined authority of these 3 agencies behind it, and it does what a legal guide in the nomenclature of UNCITRAL does. It is a text that provides guidance for the drafting of contracts and recommends solutions appropriate to particular circumstances. To me, that is more than just a textbook describing the law. But this is controversial, and I'm going to put this behind to say something even more controversial, the argument I would like to make today, because when I talk about synergies, I might also, as I said, talk in a way more familiar to lawyers. I might talk about a system of global commercial contract law, because that is exactly the implicit assumption of the tripartite guide, that these various instruments, these various model clauses, these various arbitration rules, that they're not somehow floating unconnectedly in a universe of everything, but that they actually work together, that they all have a certain place within a grander scheme, although perhaps we're unable to see that grander scheme at present. Many of you will know that there was the Swiss suggestion for a global commercial code a decade or so again, which was met with stony silence by the various countries. The code failed. But that doesn't mean that we cannot talk about a system of global commercial contract law. And as I said, look at the tripartite guide and you see the outlines of the system there. Now, I'm absolutely aware that at least 2 arguments will be made against the idea of such a system. The first is that you have a German sitting here on the podium. And of course, if you ask a German lawyer, he or she will always use 2 words with S. The first is Savigny, 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 and closely connected to that is system, system, system. So just imagine, it's not a German sitting here, but so I don't claim this because of my particular background, because what is the opposite of a system? The opposite of a system is fragmentation, or perhaps even disorder, or perhaps chaos. Is that something that a good lawyer actually wants? I don't think so. A system has didactic benefits. It makes the teaching much easier. I actually use the tripartite guide for teaching because it's such a neat pocket guide. And a system has, perhaps most importantly, gap-filling power. The system can actually guide you if you have a case that is nowhere explicitly provided for. But again, this may be a particular German point of view. The second, more obvious argument against such a system is that we have totally different legislators here in the field. Yeah? We have different agencies, we have different combinations of member states. But well, how was the system of said Swiss law developed before the Code of Obligations and the Code of Civil Law? How can we speak of a system of European private law if we have almost random directives and regulations that emanate from very different parts of the kind of European legal universe? But I'm happy to hear more criticism from you in the discussion, because I still need to write the article where I strengthen my case. Now, the president said in her introduction, and that's sometimes a little bit depressing for a legal historian, but it's probably true, we celebrate the past because we're mostly interested to determine the future. Now, I would argue that it is the task of legal scholarship to prepare such a system, but it would have to work together with an institution that is involved in the preparation of harmonized and unified global commercial law, UNIDROIT. The UNIDROIT principles would obviously be a cornerstone of such a system. So perhaps when the Governing Council meets on Wednesday, I think, they might actually commission a new study and not go for the small and pragmatic approach, but for the big approach, a study about the system of global commercial contract law. And then maybe in 2044, we'll get together here to celebrate the 50th anniversary of the UNIDROIT principles, with Joachim Bonnell as the father, not just of the UNIDROIT principles, but also as the father of a global commercial contract law. Thank you very much.
Thank you very much, Stefan. Two observations. Oliver Wendell Holmes had a notorious expression, brooding omnipresence in the sky. That was anything other than positive law. Now we're learning that there's something between positive law and that brooding omnipresence. Now there's another brooding omnipresence. Sir Roy is in Rome. I ran into him the other day. I thought he was going to be here. Maybe he will come later. Is he here? Ah, excellent. Now, talking about omnipresences, I think Fabio Bortolotti should, will he appear on the screen if I press this?
I can be there if you like me. Do you hear me? I am not on the screen.
Sorry, Professor Bortolotti.
Yes.
Everyone has the copy of your speech. We do not expect you, we do not allow you to read it. But if you would make a few remarks, you are the first participant in the Q&A session, and we look forward to it. And I'm very sorry you were unable to join.
Tell me when I should speak, and I am there free, as you like.
Now, at this moment, please.
At this moment?
Yes.
Okay. If you all hear me well, I would only say 2 words about how we came as ICC to use for our model contracts the UNIDROIT principles. I have been many years ago, when I was a young guy, working with Orgalim, and Orgalim made model contracts which were very interesting. And so in the ICC, in my commission, I made the proposal to enter in the same business in a certain sense, not as competitors, but anyhow, to organize model contracts which could be used in international trade, beginning with agency distributorship and so on, so on. I think we have 10 or 12 now at this moment. The first problem we had, what are we going to do with the applicable law? Because especially the first contracts we were examining, like agency, are very strictly linked to domestic law, and you cannot do anything of uniform, which is uniform. And so at the end, we decided that we needed to put our model contracts under a neutral system of law. And we first, you can read it on the paper, our first attempt was to make reference to the Rex Mercatoria simply. And then came the idea of the UNIDROIT principles. And so we went on that road where the last clause of the last model contracts says that the applicable law is that the question contract is governed by the principles of law generally recognized, so lex mercatoria, B, relevant trade usages, and C, UNIDROIT principles. Why have we put the UNIDROIT principles at the end? For a simple reason that in cases where the UNIDROIT principles are too good law for practice, I can come back on this when we speak about the hardship. In these cases, the arbitrator or the judge may decide, may not apply strictly the principle. But the basis is that we are convinced that we need a legal basis like the UNIDROIT principles, and they are certainly a very good solution. So we believe strongly in this. We had only a problem with hardship. I have been criticized by somebody because I was against the rules on hardship. It's not true. I am not against hardship. I don't think we should be against. But for me and for the experience I've got also speaking with in-house lawyers of big companies, hardship is a very specific problem, and hardship applies, should apply only in complicated long-term contracts, should not be too wide. And then in general terms, the idea that a party, I don't know, to a distributorship agreement or whatever says, oh, there is hardship, I want to revise the contract. I don't think it's a good idea. So I think it's very useful to have that clause, but we have, I proposed in our ICC model clause on hardship, a solution that would replace the UNIDROIT principles by choosing between, I'm already finished, three possibilities to choose for the parties. One is the party has the right to terminate the contract by saying that there is hardship. And that party takes the risk, and if there was no hardship, that party has breached the contract. The other solution is the judge, this is the classical solution, judge to adapt or terminate. But we would suggest that when you use this alternative, you already think about possible means of discussing discussing really the possibilities, the outcome, and not remaining in the air. And then judge to terminate. You can also ask the judge if he thinks that it's better to terminate the contract. So we made this this solution, which is, in my opinion, more acceptable than a simple reference to the UNIDROIT principle rules on hardship. Anyhow, this is a detail. But I want to conclude by saying that we must continue supporting the acceptance by traders and their councils of international uniform rules, and in particular of the UNIDROIT principles. I think that this is very important, and my idea is that most people, it's a bit like the Vienna Convention, most people don't believe in it because they have not even looked at them really. And so I think, to conclude, that the UNIDROIT principles are a very important means. We believe in it, and we propose our model contract based on the UNIDROIT principles, and we want to explain business people as far as possible their importance, and that they are really a very, very good law, the best we can get at the moment. Thank you.
Thank you very much, Professor Bortolotti. We miss you, but thank you very much for your remarks. We have 10 minutes for Q&A. As a courtesy, I might ask Joachim whether he has any answer, even though there was no question. No. Would you like to say something? All right. I don't know how this works, but Chris, Mr. Seppala, do we have a microphone? Oh, you have a microphone, of course. I think I have to turn mine off and you turn yours off. And please indicate to whom, this is not a comment, of course, it's a question.
This is really a comment on something in Professor Bortolotti's paper, which he didn't mention, but with which I personally have a lot of sympathy. And that is his comment, it's on page 2, regarding gross disparity. That's Article 3.2.7.1 of the UNIDROIT principles, under which a party may avoid the contract or an individual term of the contract, and I'm just abbreviating, but in certain circumstances where it gave the other party an excessive advantage, and regard is to be had, among other factors, to the fact that the other party has taken unfair advantage of the first party's dependence, economic distress, or urgent needs, or of its improvidence, ignorance, inexperience, or lack of bargaining skill. And your comment, Professor Bortolotti, in relation to that is that provision is unacceptable for contracts between traders and would make more sense for consumer contracts. And I have to say, having read through the principles myself, the one article that I found somehow inconsistent with the general tenor of the principles, that we're dealing with commercial contracts, usually with reasonably sophisticated parties, it seemed to me this article is a kind of consumer welfareism sort of article, which seems misplaced in principles for international commercial contracts. And if I understand Professor Bortolotti, that is his impression. Is that correct?
If you ask me, for me, it's correct.
Maybe others have comments.
I don't see Joachim sort of shaking. I don't know whether he wishes to say something or not. You're going to restrain yourself? All right.
Thank you. And I would just like to follow up on this last comment. That was a position I took umpteen years ago. That the gross disparity probably didn't make sense in the principles. But I've come to a different set of thinking now, because we're seeing the principles, and for example, with Contract Farming Guide, we use the principles as a background. And often the principles are used, and we hope that they're used in situations where the contracting parties are small, medium sized organizations. And in those situations, I think that the gross disparity provision makes a lot of sense, because we are seeing an extension of the principles from purely large commercial contracts to, I think, a broader use. And my thinking today is I like the gross disparity. It will rarely be used, but it's an important tool when necessary. Thank you.
You know, I think there are two governing principles. One was the old common law, pacta sunt servanda, a contract's a contract and nothing can change it. The other principle is actually on my building at Georgetown Law School, which says law is the means and justice is the end. And it seems to me the law should serve, if it can, consistent with its rigor, the means of society. It would make lawyers a lot more popular. Professor Bonnell.
Well, it's very kind of you to give me the floor after I have first declined your kind offer. I'm very attracted by Henry's argument. And I would go even further than he did right now. It's not only in my view, and I dare say this was also the view of at least the majority within the working group, that only when small or medium enterprises are contracting and entering into a contract, that this provision on gross disparity may become relevant. But also, why not the big affairs, the contracts concluded by the big guys? Why do we assume that just because it is they are two multinational companies, why should they per definition be of an equal knowledge of the surrounding circumstances and have an equal bargaining power? I think reality, with all due respect, is quite often, not always, of course, pretty much like, as far as the disproportion of these various factors are concerned, to medium or even small company contracts. Pacta sunt servanda is natural law, but it assumes that per definitionem between merchants, there's always an equal starting point. Is that really true?
But you know,
Sorry,
excuse me. Oh, Professor Bortolotti, would you like to say something? I'm sorry.
Yes, I only wanted to say it is not, I am not against the clause at the beginning when you say the fact that the other party has taken unfair advantage of the first party's dependence. I agree. Economic distress or urgent needs, I perfectly agree. But I don't agree when it says of its improvidence, ignorance, inexperience. You cannot defend yourself as a businessman by saying I am stupid, I am ignorant. That's not a reason, I think. So I think that the last part of that provision is what hurts me. Not the first one. I perfectly agree that if there is economic, if you take advantage of the economic position of the other party and so on, that's okay. But what shocks me is this improvidence ignorance, inexperience, or lack of bargaining skill. I see this mainly as a consumer problem, where I am doing something that is not my business, and I am free not to know something that I should know. Sorry,
That's what I wanted to say. I've sat as an arbitrator. It would mean we would have to determine that one party is incompetent or less competent than the other. It would be a lot of fun, but I wonder whether really it's very manageable. There was a lady who had her hand up, and we'll make this the last question if she wishes to ask the question. Stefan pointed out to me someone, well, maybe not. I'm sorry. Oh, it's a gentleman. Forgive me.
I'm not a lady, but I will still ask my question.
We
if I
trust
may.
you're a gentleman, however.
Walter Dorald. I'm at the University of Graz, and I think I would not have raised it, but now that we discussed this provision, really, I think I have something to add. Perhaps I'm skeptical about it too. Now, of course, we will all agree there have to be some limits to freedom of contract. There has to be a limit, perhaps, wherever you draw it, at unconscionability or abuse of market dominance or the like. But in principle, between commercial parties, taking the gross disparity as a starting point, and then saying, for instance, the ignorant party, to take the most blatant bit of the provision, should have a right to later on have a review and perhaps have that disparity redressed. I find that difficult, and I can add why. Austria is the last, where I'm based now, is the last country in continental Europe that has what used to be the Roman lesa enormis rule in force for all contracts, also between commercial parties. Now that means any contract that is completely imbalanced from the point of view of law, and they draw a strict line, it will be 50% plus. So if the disparity between the prestations of the parties more than half, then the disadvantaged party can later ask for a redress. Now, you might think after 2 centuries of the code in force, it is pretty much as old as the Code Civil, a few years apart, we would have clarity. But I can say this, I've worked on it both academically extensively and very limited amount in practice. And for the last 2 decades, there is between 1 and 2 Supreme Court decisions on the provision now in Austria, and many of them between commercial parties. And many of them where the bargaining power is not the issue, but rather the many questions that it gives rise to subsequently. And if you look at it historically, it's the reason why the clause has been abolished anywhere else in the globe, with one small exception, that is France. But in French law, the field of application is so extraordinarily restricted that it's practically of zero relevance. It's only for the sale of real estate and for a very particular imbalance that is much further. So I would very strongly urge parties, when they have a clause like this, to deviate from it, because it raises many difficulties afterwards in its application.
Let me be rude and interrupt you, because I'd like to leave time for coffee.
And the last sentence of it is, it gives rise to opportunistic behavior.
Well, I think this is a call for a 5th edition of the principles. And this would be high on the agenda. Well, listen, thank you all very much. How much time do we have for coffee, Anna? It's now 3:33. We have 20 minutes. No, I'm sorry. 10. And you see, this is an advantage and a disadvantaged person speaking to each other. I'll say 15 minutes. Be back in 15 minutes. Okay.